Thank you, Linda. I'm delighted to be here to talk about what I have undertaken at the ACLU, which is to defend liberty in the age of Trump. When I took the job, that was not what I thought I'd signed up for. I was recruited to the job last summer, and the executive director of the ACLU, Anthony Romero, said to me, you know, this is your dream job. You will be able to lead the ACLU's Supreme Court practice under a liberal Supreme Court. Because, of course, Hillary Clinton would win the election. She would get to appoint the replacement for Justice Scalia. And for the first time in 40-some years, we would have a Supreme Court dominated by a liberal majority. That seemed like a pretty good deal to me. I went to law school in the 1980s. My professors were all professors who grew up in the and formed their views about law and social justice in the 60s and the 70s. What they taught me about constitutional law was very much framed by the Warren Court, the liberal Supreme Court that gave us desegregation, that gave us the right of every person, no matter how poor, to have a lawyer in a criminal case, that gave us, essentially gave us the rights that we still seek to defend to this day. And then I graduated in 1984, and I've practiced constitutional law ever since under conservative majority Supreme Court. So this seemed like a pretty good deal to me. I signed on the bottom line. I forgot to put in a condition that says, you know, what if? Because who thought that there would be a what if? But of course there was. And on November 8th, before I started the job changed. So the appointment was made in the summer, but I didn't actually start until January 9th. I figured I needed an 11-day head start on President Trump. So it's a very, very different job. But in many ways, I feel deeply privileged to have this job. I think Donald Trump poses really unprecedented threats to civil rights, civil liberties, and the rule of law. He is, in many respects, dismissive of rights that people fought for generations, and that we have come to accept as part of the fabric of American life. So as a candidate, he promised to ban Muslims from entering the country, to criminalize abortion, to open up libel law so that the press could be sued more easily by people like Donald Trump, to revive the kind of aggressive stop-and-frisk policing that New York City saw for far too long before it was reformed under Mayor de Blasio, to root out voter fraud. He's apparently personally observed 3 million illegal voters. Nobody else has seen them, but he's seen them, and that is a recipe. The call about voter fraud is a recipe for using an imaginary problem, the problem of people voting when they don't have the right to vote, in order to suppress the vote of those who are unlikely to vote for people like Donald Trump. He promised to jail his opponent, Hillary Clinton. As a president-elect, he urged that those who burn the American flag should be jailed and have their citizenship stripped. He proposed to revive the CIA's practice of torture. This is a pretty astounding list, and it comes from the man who is now the President of the United States. When you take them in whole, what you see is just a kind of dismissive attitude towards the fundamental individual rights and liberties that define us as a nation. So it's a serious threat. But I think we can stop him. I think we, the people of the United States, can stop him. And when I tell people that, they often ask me, what did you just smoke? Or what have you been drinking? Because tell us how you're going to stop Donald Trump. He's the President of the United States, most powerful elected office in the country. He has a Republican House, a Republican Senate. When Neil Gorsuch is confirmed to the Supreme Court, which will probably be this week, he will have a Republican majority Supreme Court, and about 2/3 of the states' governments are in Republican hands. How are you going to stop him? And I think it's a decent question, but I think we can stop him. And as I said, if we stop him, it will be the actions of we, the people, of citizens engaged. And the reason I believe we have the possibility to stop him is that I have never seen in my career as a lawyer the kind of citizen engagement that we have seen since November 8th of 2016. And that is where our salvation lies. So why do I think that? Well, I'll talk about two examples from the past, and then some examples from the immediate past, the early days of the Trump administration. The first is, I think you might have had the same question after 9/11. Who's going to stop George Bush from doing whatever he thinks is necessary to protect the American people in the wake of this horrific attack on the World Trade Center and the Pentagon, in which 3,000 innocent civilians were brutally killed? Who's going to stop him? He, too, had a Republican Congress for most of his 8-year tenure. He, too, had a Republican majority Supreme Court. In fact, it was that Supreme Court that put President Bush into office by deciding Bush versus Gore, stopping the recount and ensuring that he and not Al Gore was our president. He had 90% approval ratings in the wake of the attacks of 9/11. And he had a history of presidents being given essentially a free hand in dealing with the enemy in times of crisis in the United States. A history of courts, Congress, and the American people standing back and letting the president do what he deems necessary, whether it be locking people up for speaking out against the war, something that was done to hundreds during World War I, and the Supreme Court upheld the action, or interning 110,000 people simply because of their Japanese ancestry during World War II, something that Congress did not stop, something that the court blessed. And indeed, President Bush initially responded in the war on terror by acting as if he could not be checked. And so he authorized things that really we had not seen before. He authorized extraordinary rendition, the practice of abducting someone in country A and delivering them to country B so that country B could torture them for us. He authorized the disappearance of suspects into secret CIA prisons where people were held for years at a time without even our acknowledging that they had been detained. That's what a disappearance is. It's an abduction, a detention, without acknowledging that the person is detained. He authorized the CIA to torture. He authorized the detention of over 770 people at Guantanamo without any hearings, without any access to the courts, and he authorized warrantless wiretapping of Americans, something that federal criminal statutes prohibited, but he asserted the right to override. But by the time President Bush had left office, he had been forced to curtail all of these measures. He had released 500 of the people at Guantanamo. He had emptied out the CIA's secret prisons. He had terminated the extraordinary rendition program. He had suspended the CIA's torture program, and the warrantless wiretapping program was now under judicial supervision. So what accounts for that change? How did we push back against Bush, given that there was a Republican Congress, a Republican court, strong approval ratings, and a history of deference? And I think the answer is the work of citizens who cared about civil liberties and civil rights and engaged in a variety of tactics, some of them inside courts, but most of them outside of the courts, to push back against President Bush. And it's not that President Bush changed his mind and decided, well, actually, we don't need to torture, we don't need, or we made a mistake. You know, if you read President Bush's memoir, and I'm not recommending it, but if you read President Bush's memoir, you will see he doesn't think he made a single mistake over the 8 years of his tenure. So these changes were not made voluntarily. He was in one way or another compelled to do so. So what caused that? So as I say, I think the answer lies in the work of citizens coming together in associations that care about liberty. And some of the answer dates back far before 9/11. So I'll give one example. I talked already about the Japanese internment during World War II. The end of World War II, that went up to the Supreme Court in a case called Korematsu versus the United States. Fred Korematsu, a man who refused to be interned and was tried and convicted for his standing up for his rights. And the Supreme Court upheld his conviction and said the president can lock these people up, and just because he's doing it on the basis of their race and ethnicity, not a problem. Not a problem. And at the time, Justice Jackson, one of the great Supreme Court justices, wrote a dissent in which he said, this is like a loaded weapon. Upholding this kind of action is like a loaded weapon because it's sitting around waiting for the next president to pull up and use in the next crisis. And at the time, Justice Jackson may well have been right, that was the danger of that decision. But I think, in fact, over time, that decision has changed. The meaning of that decision, the precedential effect of that decision has changed so that it has become not a loaded weapon that a president can pick up and deploy in another time of crisis, but rather an anti-precedent, something that we should not repeat, a mistake, and a warning. And so how did that happen? How did this decision, which upheld internment, turn into a decision that is seen by virtually the entire bar, including the justices on the court, as one of the most shameful decisions in our history? And the answer lies in the action of citizens who came together, did not accept that decision as the final word, and engaged in a long-term campaign to overturn Korematsu in the court of public opinion, in the court of history. And they started small. They did things like fought to get the property back from people who were interned. So all the Japanese and Japanese Americans on the West Coast were interned, put into detention camps, sometimes called concentration camps, and made to leave their homes, and then people took their homes. So part of the work was just getting their homes back. Another small part of the work was to get their citizenship back, because many of them were compelled, coerced into giving up their American citizenship while they were in these camps. And so Japanese American groups and the ACLU working together got their citizenship back. And then there was a fight to get a commission of inquiry, just a commission of inquiry to reassess what happened. Not to do anything, but just to study what happened. And that commission was formed, and it was a bipartisan commission, and it came out with a very critical assessment of the practice. And then an academic uncovered evidence that the Justice Department had misled the Supreme Court about the threat that the Japanese American population posed to the United States. It didn't actually pose any threat to the United States. And there was evidence that it didn't pose a threat to the United States, but the Justice Department didn't present that. And that was uncovered, and that on the basis of that new evidence, people went back into court on Fred Korematsu's case and other people who had been convicted and sought to overturn those convictions. And then they got Congress in 1984 to enact a statute that formally apologized for the internment and paid $20,000 in reparations to the survivors, signed by Ronald Reagan. And that statute was essentially the culmination of 40 years of fighting back against Korematsu, so that today Korematsu is not a precedent, but rather something to be avoided. A lesson in what you don't do in time of crisis, which is to defer blindly to the president. And I'll never forget when I was standing in line to go hear the argument in the Supreme Court in Rasul versus Bush, which was the first Guantanamo case to reach the Supreme Court. And that case was filed by the Center for Constitutional Rights by one of my mentors, Michael Ratner, a man who passed away just last year. And when he filed that case, he said, I asked him, you know, what chance do you think you have of winning this case? He says, it's absolutely hopeless, completely hopeless. But he filed it anyway. And he lost in the district court, he lost in the Court of Appeals, but then the Supreme Court took the case. And I was in line with my predecessor in this job, a guy named Steve Shapiro. And I said to Steve, you know, how do you think the court's going to deal with this case? And he said, well, I don't know how they're going to come out, but I do know this. They have to have Korematsu at the back of their minds as they are hearing it. Why? Because Korematsu was a case in which the court had deferred to presidential claims of authority and violated basic human rights. And now President Bush was claiming that the court should defer to his detention of foreign nationals at Guantanamo without any inquiry into their human rights. And he was right, and it wasn't just at the back of their minds, it was at the front of their minds, because Fred Korematsu himself, in his 90s, filed an amicus brief, a friend of the court brief, in the Supreme Court, saying essentially, don't make the same mistake twice. So that work, that concerted work of civil society over time, overturned, in effect, a Supreme Court constitutional decision and turned a loaded weapon, something that the government could use against the people, into a object lesson in what not to do. So, if we could push back, and there were a whole host of other sorts of activities and campaigns that were engaged in after 9/11 to bring pressure to bear on the Bush administration. People brought, one was colleagues of mine at the ACLU filed a Freedom of Information Act request. That's a law that says that you can ask for official government documents about some subject. But it has all kinds of exemptions. And one of the exemptions is if the information is classified or concerns national security, you don't get it. So the ACLU decided, well, let's file an FOIA request, Freedom of Information Act request, for documents relating to the CIA's torture interrogation program. And some of the, my other colleagues at the ACLU, you know, sort of made fun of the lawyers for filing that case. They said, you know, have you cleared away enough space on your bookshelves for all the papers you're going to get from the CIA from filing a Freedom of Information Act request about a secret program? And one lawyer said, I'll give you $1 for every page you get from the CIA. Well, 8 years later, they had received over 100,000 pages of documents. That lawyer never paid up his office. And there wasn't room on the bookshelves for all of these documents. And it turned out that they got all kinds of critical information about the program, sometimes from agencies that wanted to distance themselves from the program, distance themselves from the FBI, I mean from the CIA program, including the FBI, and sometimes from the CIA through the courts. But that, it came out in dribs and drabs over the course of many years, and every time it came out there was a new revelation about the program, a new story in the newspaper, more transparency about the program, and this was a program that could only be deployed in secret, because once you brought it to light, it had to be shut down. It was not sustainable to be torturing people once we acknowledged that that's in fact what we were doing. So by the end of his term, President Bush had retreated on all of these measures, and it was because civil society groups pushed back, and pushed back in a variety of ways over a variety of through a variety of forums over a long period. And I think what it illustrates is that we are a democracy, turns out. We're sometimes an odd democracy, but in a democracy, liberty and rights depend in significant part for their protection on the engaged action of citizens organized through civil society fighting for those rights. I'll give you another example. Both of these examples come from my book, Engines of Liberty, which in some sense might be seen as a very long application for my current job, except that it took me about 6 years to write it, and I didn't know that this job was available. But because the subtitle is The Power of Citizen Activists to Make Constitutional Law. And the argument is that the work of constitutional law takes place primarily outside of the courts, not inside the courts, not by the Supreme Court, but by the people engaged in concerted activity through civil society organizations. So one of the organizations that I talk about in the book, probably the most powerful civil liberties organization in the United States, and that's not the ACLU, but the NRA, National Rifle Association. In 1991, Chief Justice Warren Burger, a conservative Republican, said that the idea that the Second Amendment protects an individual right to bear arms was one of the greatest frauds perpetrated on the American people in his lifetime. For 100 years, the courts had said, there is no individual right to bear arms. The Second Amendment is about protecting the rights of states to have militias as a check on federal power. It is not about the rights of individuals to have guns in their homes. But that's not the way the NRA saw it. And the NRA undertook a campaign starting in the late 1970s to change the understanding of the Second Amendment and to protect an individual right to bear arms. And they knew they couldn't win that case by filing a lawsuit in federal court, because they would just lose, because over 100 years the courts had said this is not a right, and Chief Justice Burger had said it's a fraud. So they went elsewhere. And they went principally to the states. And they went state by state, getting state legislatures to either adopt laws protecting the right to bear arms or amend their state constitutions to protect the individual right to bear arms. So that by the time 2008, when the Supreme Court takes up the question, does the Second Amendment protect an individual right to bear arms, in a case called Heller versus the District of Columbia, by that time, because of the political work that the NRA had done, virtually all the states already protected an individual right to bear arms under their state laws and state constitutions, making it a much smaller step for the Supreme Court to say there's also such a right in the federal Constitution. They also supported scholars in digging up evidence to support the notion that maybe there was some people who thought that the Second Amendment protected an individual right to bear arms. And by the time the case got to the Supreme Court, the consensus in the law schools on this question had shifted from virtually 100% saying there's no individual right to a significant plurality saying there is an individual right. It got Congress to endorse an individual right to bear arms in 2 pieces of legislation before the case went to the Supreme Court. And they got the executive under President Bush when the Attorney General was John Ashcroft to reverse the Justice Department's position and say there is an individual right to bear arms. So by the time it got to the Supreme Court, they'd already gotten the states on board, the legal academy on board, the Congress on board, and the executive branch on board. And they did that through politics. They did that by engaging their membership. They have 5 million members. They have another 15 million people who think they're members, say they're members, but don't pay their dues. And the NRA, I talked to a lot of NRA people for this book, and you know, they said, well, we'd love to have their dues, but what we really want is their votes, their allegiance. And so we're happy to have them say they're members and think they're members, even if they're not paying, because the source of our power is that when we oppose a bill, we can mobilize those 20 million people. When we see a candidate who favors our right and running against a candidate who doesn't favor our right, we can send orange cards to 20 million people and urge them to vote for the one candidate over the other candidate, and they will do that. They understand the democratic roots of constitutional freedoms. So whether you agree with that constitutional vision or not, I think it's important to see the power of mobilizing citizens for, to protect and advance a particular right. So these are stories that illustrate the power of people to protect and advance liberty. And that is what we need to rely on today. I've already talked about all the threats that Trump poses, and they are considerable. But look at the reaction that we have seen since Trump was elected. Look at the women's marches across the country, indeed across the world, that made the Inauguration Day crowds look puny. Look at the look at the ACLU. For a decade, we had about 500,000 members. And it would go up under Republican presidents because people would be more concerned, and it would go down under Democratic presidents, people would be less concerned. So we would go maybe up to 550,000 under President Bush, down to 425 under President Obama, but we couldn't really change it. For 10, 15 years, we could not really get out of that 500,000 mark. We are now at 1.2 million and counting. 1.2 million and counting. We have never received more requests and offers to volunteer. Virtually every law firm in the country, tech firms, ad firms, ordinary citizens calling to say, what can we do to help? And why is that? Why are people coming to us in ways that we've never seen before? Precisely because they see the threats that Trump poses, and they see that those threats are to the very rights and liberties that the ACLU has been around and fighting for nearly 100 years. And they say, okay, it's time to pony up. It's time to join. It's time to step up and stand up for the values and rights that we believe in. We saw that at the airport demonstrations on the Saturday after the executive order instituting the Muslim ban was signed into law. On that day, tens of thousands of people got up and went out to airports to protest. This is remarkable for two reasons. One, the tactic of targeting foreign nationals in the name of national security is a tried and true one, and it generally does not engender much citizen opposition. Because what the president can say is, look, I'm not taking your rights, I'm protecting your security, and I'm not asking you to sacrifice your rights, I'm sacrificing somebody else's rights. But this time, people didn't accept that. And so tens of thousands of Americans went out to the airports to protest even though their rights were not directly at stake. And secondly, they went to airports. You know, I don't know about you, but the airport is about the last place that I want to be in unless I have to go somewhere. They are sterile, soulless environments, right? They suck the energy out of you. And yet, people got up off their couches, got in their cars, or their Ubers, or their Lyfts, probably more Lyfts than Ubers, but they got in their Lyft, and they went out to the airport to protest for somebody else's rights. That is a remarkable thing. The town hall meetings that were held across this country just about a month ago during the congressional break to talk about ACA repeal, Obamacare repeal, and to push back against the proposal to repeal health care insurance. The calls that Congress people received on the ACA, which ran 10, 15, 20, 25 to 1 against the repeal measures, and ultimately led to the failure of President Trump to deliver on one of the most central promises of his campaign. These are remarkable responses. They are, and if we can continue these responses, I think we can push back against President Trump, we can limit the damage that he can do, and we may actually transform this country in a significant way by coming together and standing up for many of the principles that we have taken for granted for far too long. So let me say a couple more words about the executive order, because in some sense that's been the principal legal fight, since President Trump has come into office. The executive order was signed on Friday, January 27th, 1 week from the day that President Trump took office. It was his first major effort. By that night, the ACLU, along with students from a clinic at the Yale Law School and a group called the National Immigration Law Center, had filed the first lawsuit challenging the legality of the executive order. That night, we filed it at 5 a.m. on Saturday. The order came out at 4 p.m. On Friday. We filed on behalf of 2 Iraqis who had visas to come into the country, had been stopped at the airport because of the ban. That evening, Saturday evening, we sought a temporary restraining order, an immediate injunction against the order. And the argument was held that evening, on a Saturday evening, on a case we'd filed Saturday at 5 in the morning. Saturday at about 8 in the evening, the judge held a hearing. Over 1,000 people gathered at the Brooklyn courthouse to hear the result of the decision. And they were chanting. There's a video that's on the web. People are chanting, ACLU, ACLU, we will stand with you. That has never happened before in the history of this country. I mean, remarkable. And that was led to the first judicial order and joining the enforcement of the of the Muslim ban. Shortly thereafter, a judge in Washington enjoined it nationwide in a suit brought not by individuals, not by the ACLU, but by the Attorney General of the state of Washington and the Attorney General of the state of Minnesota. So now you have state attorneys general pushing back against President Trump. And in our case and in that case, we had support from many other state attorneys general. We had support from 130 Silicon Valley companies, including some of the biggest companies in the world, Google, Apple, Uber, and others. We had the support of the presidents of all the major universities in this country who condemned the ban. We had the support of Nobel laureates of all of the major science institutions in this country, of retired generals and admirals and national security officials. Indeed, on the Saturday after the order was issued, Michael Hayden, General Michael Hayden, who was the head of the CIA and the NSA under President Bush, a major defender of the CIA's torture program. I have debated him on a number of occasions. That weekend, he put out a tweet. Interesting that the former head of the CIA and NSA is tweeting, but he puts out a tweet that says, "How about that? ACLU and I in same corner." Dick Cheney came out against the executive order. And John Yoo, who was the lawyer who infamously wrote the memo authorizing the CIA to torture, despite the fact that there were international laws, constitutional laws, and federal criminal laws prohibiting torture, he wrote an op-ed for the New York Times calling it "Executive Power Run Amok." And so with all of that resistance, what did the courts do? They sided with the resistance and against the president. And they did so on an immigration case where presidents generally have broad authority. And they did so where the president claimed he was acting in the interest of the national security, where again, the presidents generally have a great deal of authority. When the Washington judge issued his decision, President Trump tweeted and called him that so-called judge. Not a wise thing for a president to do if his actions are going to be reviewed by courts. When the Ninth Circuit affirmed Judge Robart's decision, President Trump tweeted, "Outrageous decision, we'll see you in court." That was our phrase. The ACLU was the one that said, "We'll see you in court." He took it from us, but it also made no sense because he was in court. That's where he had lost. "We'll see you in court." When I knew that we had hope and that we had a real shot at pushing back was in the week after the Muslim ban was enjoined. As I said, we had put 2 days after, I have to go back for 1 second, 2 days after President Trump was elected, we took out a full-page ad in the New York Times and the Washington Post, which said, "We'll see you in court." President Trump, congratulations on your victory, but if you carry out the measures that you promised during your campaign, we will see you in court. And we did. We did. So the week after that first victory in the Brooklyn case, the New York Times crossword had a clue. The clue was, group that said to President Trump, "We'll see you in court." And the answer was ACLU. At that point, I knew we had arrived. So all of this, so this is just one example. Then President Trump issued a second executive order. We filed a lawsuit. The state of Hawaii filed a lawsuit. Both lawsuits, the district courts have enjoined the executive order as an act of religious discrimination against Muslims. And did so the day that the order went into effect. So he can be stopped. Indeed, I think the story thus far of the first 100 days is that he has been stopped. In those first weeks when this executive order came out, there were a whole number of other draft executive orders that got leaked. One ordered the CIA to look into reviving the black sites, the secret prisons, and reviving the torture program, and bringing more people to Guantanamo. That order has never been issued. Another created a right of people who have certain religious convictions to not have to follow the law. Which religious convictions were they willing to protect? Those who believe, by virtue of their religion, that marriage is only between a man and a woman, that life begins at birth, and that there shouldn't be sex outside of marriage. If you have those religious beliefs and you act on those religious beliefs to deny women access to contraception, to deny equal treatment to gays and lesbians who are seeking to marry, you're protected under this executive order. It's never been issued. What happened was they came out, there was tremendous condemnation and criticism of them, the leaked versions, and President Trump hasn't had the temerity to put them into place. I've already talked about the repeal of Obamacare. But in that repeal of Obamacare was a plan to defund Planned Parenthood. That, too, they have failed on thus far. And the reason, I think, that they have had such difficulty, besides incompetence, is resistance. It's the fact that we live in a democracy. And when you are a president who comes to office having lost the popular vote, when you take office with the lowest approval ratings of any president that has taken office since we've been, figuring out approval ratings, when your approval ratings plummet from the time you take office to now when they're in the 30s, you're not going to be very effective at doing the things you want to do. And all of that, I think, reflects a deep-rooted concern in the American people about the values and rights and liberties that we have fought for as American people for so long, that are reflected in our Bill of Rights, and that President Trump threatens to take away. So Learned Hand, who was one of the greatest, is often described as the greatest American judge not to sit on the Supreme Court. He was a judge on the U.S. Court of Appeals for the Second Circuit here. I don't know if he was the greatest, but he certainly had the greatest name of any judge not to sit on the Supreme Court. Learned Hand once said, "Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can save it. While it lies there, it needs no constitution, no law, no court to save it." Now, like many great quotes, this is an overstatement. We actually need a constitution, we need courts, we need laws. Some of what is so disturbing about, fundamentally disturbing about President Trump is his lack of respect for the Constitution, the courts, and the laws. But nonetheless, Learned Hand identified a critical truth here, and that is that ultimately the protection of liberty lies with us. It lies in our hearts. And so what I think is so critical is the work of organizations like the ACLU, like the Center for Constitutional Rights, like Planned Parenthood, like the NRA, who stand up for constitutional visions and bring citizens together in defense of those visions and nourish the liberty that lies in Americans' hearts. And that, in the end, will be our salvation. So let me close with another quote, and then I'm happy to take your questions. And this is a quote about the relationship between hope and action. The relationship between hope and action. It comes from a book written by Roberto Unger and Cornel West. At the time, they were both Harvard professors. I actually end my book, Engines of Liberty, with this quote. And it comes from a book they wrote called The Future of American Progressivism. They wrote it about a decade ago. It's a very thin book. I don't think they saw much future in American progressivism. But it has this, I think, very important notion. And they write, hope is more the consequence of action than its cause. As the experience of the spectator favors fatalism, so the action of the agent produces hope. As the experience of the spectator favors fatalism, so the action of the agent produces hope. And what they mean by that is that the causal connection between hope and action is not that hopeful people, optimistic people, act. It is not that you are born with a hope chromosome, and that's why you go and act. The causation is the other way around. By acting, you produce hope. By acting, you produce hope. And in the same way, by sitting back, you favor fatalism. If you sit back and you spectate, very easy to be fatalistic. And both of these things have a snowballing effect. That is, if people sit back and spectate and don't engage, well then the actions of the few who act will not likely be very successful, and the fatalism will be proven accurate. Well, there was no point in my getting off the couch because there's no point. See? But it's also true that action produces hope in a snowballing way. So the more people take action, the more successful that action will be, the more they will produce results that are positive, which will then encourage others to take action. So as I see it, we have two choices. If you agree with me that the current president poses serious threats to the basic rights and liberties that define us as a nation. One is to sit back fatalistically and spectate, and the other is to act and produce hope. And therefore, I think we only have one choice. Thank you very much.
We don't have a moving mic at the moment, so if you could speak as loudly as possible, we do. Okay, so just raise your hand. David will call on people, and the mic is moving around.
Oh. Hi, thanks for coming.
Sure.
You spoke a lot about the obvious threats that President Trump poses to civil liberties, constitutional rights. I was wondering if, in your opinion, there's any overlooked severe threat that we as citizens, the media included, are really overlooking in this presidency.
Yeah. So, I touched on some of them. I touched on the ones that he, trumpeted during the campaign, so to speak. But I think there are many others. We certainly expect that there will be, in the field of national security, in the field of surveillance, in the field of executive power, serious challenges that we will need to respond to. We haven't seen that yet. It might come in the wake of another terrorist attack. It might come without another terrorist attack. What we do know is that he has surrounded himself with people who believe in a very, very strong executive, who have a kind of Islamophobic conspiracy view of the world, and very much want to instantiate that in policy. So I think we're going to see the designation of Muslim civil society organizations. We're going to see more targeting of Islam and Muslims. I think we'll see more aggressive surveillance of mosques and indeed of ordinary American citizens. We'll see more aggressive uses of drones and uses of military authority to respond to terrorist threats abroad. So that's one area that I think we haven't yet seen it come to fruition, but it will. The voting rights, which I talked about before, we haven't yet seen the kind of voter suppression measures that the voter fraud myth that Donald Trump is propagating lead to. But we will. You know, there's still a year and 10 months or so till the next critical election, which is the midterms, and you can be sure that there will be efforts during that period to cut back on access to voting by the poor, by people of color, and the like. And the way that that is done is through putting in voter ID laws and the like, which create barriers to voting on behalf of the poor. We have already seen at the state level the emboldened state legislatures passing more and more restrictive laws on women's reproductive health, because President Trump said he's committed to criminalizing abortion and overturning Roe versus Wade. And you know, look at his Attorney General. He appointed for his Attorney General Jeff Sessions, probably the most conservative member of the Senate, somebody who voted against extending a hate crimes law to hate crimes motivated by bias against women and gays and lesbians, saying, I just don't see that they suffer from any kind of discrimination like that. Well, if you can't see discrimination, you're not going to enforce the laws that prohibit that discrimination. And so the Justice Department, which is now headed up by Jeff Sessions and which has an Office of Civil Rights whose job is to protect voting rights, to protect against hate crimes, to protect against sex discrimination and sexual orientation discrimination and the like, is now headed up by someone who doesn't see those as priorities. Someone who believes it's problematic for the federal government to go into a city like Chicago after the crises of police abuse and police killing of people of color and force reforms. He wants to pull back. And so you're going to see, I think, from the kind of vacuum of enforcement of civil rights, a growing civil rights violations around the country. Not pushed by the federal government. They'll be committed by state actors, but without the kind of break that the Justice Department in enforcing the civil rights laws is supposed to provide. Yeah.
First of all, thank you for all the work you're doing. I know it's some days, even just as a citizen, it feels like a giant game of outrage whack-a-mole, where you think you've done something and you work to support it, and then he comes out with something else that's just ridiculous. And now that I live in New York, it's great to write to my congressmen or my senators, and I feel like I have a voice and a way to counter them and hold them accountable for what they do. But previously I lived in Washington, D.C., where I didn't have that. And I was wondering what you would say to my friends who still live there, to say, I don't have anybody that's listening to me. There's no one representing me in Congress. And as you know, Indivisible points out, that people don't really listen to anyone who's not their constituent. So what can they do to stay active and help resist this president?
So I think we can all, there's all sorts of ways that all of us can be active. So some people, you know, I get a version of this question all the time, right? Some people say, I live in a state where there's no way that I live in a district that's gerrymandered, and there's no way that my elected representative will care what I say, because he's guaranteed to get reelected no matter what. Or I live in a district where I agree with 100% with what my congressperson does, but he's going to do it without my calling him. Why bother calling him? I think they count the calls regardless of where they're from. They can't always determine where the calls are coming from, and they are, in part it's about making noise. It's about expressing concern by showing congressmen that this is actually what you're proposing to do is something that a lot of people care strongly about. And yes, they count verifiable constituent voices more than non-verifiable non-constituent voices, but I don't think they count non-constituent voices for nothing. You can go out and demonstrate. There are many efforts, often spontaneous, to go out and demonstrate, to show our support for Muslims in the wake of the Muslim ban. Those things make a difference, and they make a difference when there are significant showings. And so the more people that go out, the more they will make a difference. You can appeal to government officials at lower levels, right? Much of what goes on in the United States in terms of the government's regulation of us does not come from the federal government. It comes from the state governments, or it comes from the local government. And those governments are much more accessible, actually. We don't pay as much attention to them all the time, but they're much more accessible because it's smaller, a smaller universe. And so reach out to your state legislature, reach out to your state attorneys general. We saw with the Muslim ban that many states' attorneys general have stood up against Trump. Why are they doing that? They're doing that because they see that people care and people want them to stand up against Trump. And so they're going into court, and that gives a kind of legitimacy to those claims that an individual claimant or a group like the ACLU doesn't quite have. And so they can be encouraged to do that. So, I think that again, the message of my book, Engines of Liberty, which is consistent with the message here, is that get involved, get engaged through organizations that stand for the beliefs that you care most about, and they will identify actions that are important, strategic, and will be effective. But they need people to respond. And the more people that respond, the more effective they will be. So I think pick your organization, whatever whether you care about the environment, whether you care about women's rights, whether you care about workers' rights, whether you care about energy, whether you care about civil rights. Pick organizations that have been fighting this battle, join them, check their websites. When they say take action, take action. When I was doing the NRA, looking at the NRA, I talked to a former NRA president, and I said to him, why is it that your members, and because the NRA members are legendarily more responsive to these kinds of requests than the members of almost any other civil liberties or civil rights organization. Everyone says, how does the NRA do it, right? And what this president kept coming back to is he said, you have to have the threat. You have to have the threat. And for the NRA, the threat is, for gun rights believers and gun owners, the threat is liberals will confiscate their guns. And liberals may dismiss that threat, but precisely because liberals are so dismissive, that just reinforces for their members the likelihood that they would take our guns if we didn't stand up for them, right? So they have that threat. That's a threat that their members believe in, they find credible, and they act. Well, we now have the threat. Donald Trump is such a profound threat to so many rights and values in this country that he has, despite himself, united us in ways that I think we have not been united before. I mean, it's interesting, Hillary Clinton ran as the great uniter, but in some ways, Donald Trump has united us more than Hillary Clinton possibly could. And if we had been mobilized and united on November 8th in anything like the way we have been since November 9th, the election would have come out the other way. So, yeah. Here you.
Thank you. The areas that I'm concerned about are those that don't have what I would think of as a kind of natural victim who would have standing to sue. And the three areas I'm kind of thinking of right now are the blatant nepotism going on, which we all have seemed to kind of shrug off, but it's really shocking when you think about it. The enmeshing of Trump's business interests, that doesn't seem like there's really any way for anybody to enforce that. And then what you had mentioned earlier, the idea that consent decrees between the Justice Department and cities about policing might get ripped up. That one, maybe there's some enforcement mechanism since it's a court-ordered decree, but I'm not entirely sure who would have standing to try to enforce those. So I was wondering if you could address those areas, or just pick one of them if you want.
Yeah. So it depends. If your view is, you know, can you sue about it? Sometimes you can't. There are some problems that are not, you know, addressable through the courts, but that doesn't mean they're not addressable. The courts are just one forum through which we can resist rights abuses. Much of the resistance, I mean, again, you know, I keep coming back to the NRA as an example, but I think it's a good example. You know, even after the NRA was successful in getting the Supreme Court to recognize an individual right to bear arms, even after that happened in 2008, today, the most important protector of the right to bear arms in this country is not the Supreme Court, it's not the federal courts, it's not lawsuits, it's the NRA. And they protect it politically. So they're able to stop bills from getting enacted that would clearly be upheld as constitutional under the Second Amendment by the Supreme Court. They're able to get bills enacted that protect the rights of gun owners that clearly are not required by the Constitution. So you know, they don't stop at the courts. The courts are just one other forum, and nor should we. So there are certain things that are hard to challenge legally. But if we make them a political issue, they become, we can resist in that way. President Bush, no court ordered President Bush to release 500 people from Guantanamo. No court ordered him to empty out the CIA's secret prisons. No court ordered him to stop the CIA's torture program. No court ordered him to cease extraordinary renditions. And yet, by the time he had left office, he had done so. Why? Because citizen activism had made those decisions and those programs costly, politically costly, in a variety of ways, often in terms of our relations with other countries, such that he had to pull back. He had to moderate his actions. So, you know, with consent decrees, it's possible in some where there's a consent decree, it's possible for citizens in that city to intervene to try to enforce the consent decree if the initial enforcer has absented itself in some significant way. On the conflicts of interest, there's a constitutional provision that nobody heard of until President Trump became president called the Emoluments Clause, which prohibits the president from obtaining any payment or gift from a foreign state official or a domestic state official. And most presidents prior to President Trump have sought to avoid that problem by getting rid of, selling all their assets and putting their assets in a blind trust. So there's a separation of their private interests from their public responsibilities. Trump has refused to do that. That's a violation of the Emoluments Clause, in my view, But who has, your question, who has standing to challenge that? A public interest group has brought a lawsuit to do that. I think it's unlikely that that suit will have standing to sue. But a business that is competing against Trump business in a particular place, a hotel in Washington, a restaurant in Washington or Chicago that competes with a Trump restaurant and Trump hotel, could, I think, bring such a suit. So, you know, you have to think a little bit more creatively sometimes to figure out who can have standing. But I think the principal point, the most important response is we shouldn't think about courts as the only or even the primary avenue of defense. They are a significant avenue of defense, but they are not exclusive by any means. Yeah. Okay. Yeah. This will be the last question. In the front. I don't know where I don't know where. Yeah. Here you
go. Thank you for being here, Mr. Cole, and congratulations on the appointment.
Thank you.
So a lot was mentioned. Your book focuses on civic engagement to move us forward to either defend or bring about crystallization of our constitutional rights. There are a lot of people, citizens who may not otherwise choose to rally or use political means, but instead choose to use social media to bring an awareness, and they use social media as their form of engagement. Is that effective? And if those people believe, if there are people who believe that it is not as effective, could you shed some light on the use of social media to also be engaged politically?
Yeah, great question. So, you know, without question, social media has transformed politics in the United States. Right? The notion that we have a president who tweets every morning, you know, that gives you some indication. The fact that the White House and even the CIA had to open a Twitter account to keep up, right, shows that this is an important form of public engagement, of public discussion, of public mobilization. You know, I think you wouldn't have had the airport demonstrations without social media. It was a number of organizations of citizens, many of them grassroots, that said, hey, let's, you know, this is outrageous. Let's go to the airports. And they were able to do that and respond on a dime because of social media. So I think social media is critically important. At the ACLU, we are, you know, very strong believers in the use of social media to push out our ideas, to educate the public, to mobilize, to notify people of issues that they ought to be concerned about. I don't think you should limit your activism to social media. I think that there is some concern that people feel like, well, if I like, you know, a tweet that says, you know, oppose the repeal of the ACA, well, I've made my voice heard. No, not really. You know, I mean, you know, if you've made your voice heard to that person who now has an additional like on his tweet, but that's not terribly effective, right? But I think social media is useful for getting the word out quickly, and sort of educating people and mobilizing people. But then there needs to be follow-up, and the follow-up might be a meeting like the huddles that took place after the Women's March, or the group meetings that Indivisible has inspired, or at the ACLU we have begun, since we have this newfound energy and newfound membership, we have begun a mobilization campaign for our members. It's called peoplepower.org. You can see it at the top of our website. It was launched through social media just a couple weeks ago. But here's an example, right? What did it do? What they do, they held a launch event in Miami, 1-hour event. 2,500 people came. But they didn't just do it in Miami for those 2,500 people. They also, through social media, invited people to hold events in their homes, or in their schools, or in their churches, or in their synagogues or in their mosques to bring people together to watch the event together. And the event was about how you, as a citizen, can engage at the local level in political action to resist Trump and to stand up for the rights and values that we believe in. And they got 2,200 people with about 10 days' notice. They got 2,200 people to hold these events. And somewhere between 100,000 and 200,000 people attended the events. And it was important to have the attendance, right? People come, because it's people come together physically. I think that builds a sense of identity and a sense of connection that's stronger than the, clicking on your phone, which has some value, but, at the end of the day, it's as alienating as it is unifying. And it was that that event was live streamed on Facebook, and over 1 million people watched it. And now, and we've launched now a Freedom Cities campaign through that, which asks those people who came together to take on this platform of requests and go to their city mayors or their city sheriffs and ask them to respect the rights of immigrants, to not enforce the federal immigration law, which states and localities do not have to enforce and many don't want to enforce, and to stand up for the rights of all who live here as against the kind of ramping up of immigration enforcement that President Trump has announced. So that was, we couldn't have done that without social media. It was social media that allowed us to get all those people together. But I think it was critically important that we got those people together and then, encourage them to go out and take action in person, human contact, not just sending a tweet. Thank you all very much for coming.